You know that moment, right? You're signing up for something new and you just scroll, and click, I agree. We've all done it. But have you ever stopped to wonder what's actually in that fine print? And more importantly, what happens when it contains a really nasty surprise? Well, today we are diving into the landmark legal battles that decide when you're actually bound by terms you might have never even seen. Okay, think about this. It's something we do all the time. You pull into a car park, you're in a rush, a machine spits out a ticket, you grab it, and you go find a space. It's a totally normal, everyday thing. You probably don't give it a second thought. But what if something goes wrong? What if on the back of that little ticket or on a sign you drove right past, there's a clause that says the car park isn't liable for any damage to your car? At all. Are you just stuck with that? This exact question, it's at the very heart of a huge and really important area of contract law. Now, the answer to that question didn't just appear overnight. Nope. It was hammered out in courtrooms over more than a century. And to really get our heads around the rules we all live by today, we need to follow the story through 5 absolutely crucial legal cases that, honestly, changed everything. So, our journey starts with the most basic question of all. Did you even know there were terms to agree to in the first place? This is the first hurdle any company has to clear, and it all comes down to a legal idea called notice. Let's go way back to 1877, to a railway station cloakroom. This case, Parker v. Southeastern Railway, is where it all began. Mr. Parker leaves his bag and gets a ticket. On the back, in tiny print, it says the railway's liability is limited to just £10. Of course, his bag was worth more and it got lost. So was that clause binding? The court came up with a truly game-changing idea, the reasonable notice test. And here's the kicker. The question wasn't whether Mr. Parker actually read the terms, but whether the railway did enough to let a reasonable person know that the terms were even there. Big difference. But reasonable notice isn't just about if you were told. It's also about when and how. So a few decades later, 2 more cases refined this. In Ollie v. Marlborough Court, a notice on the back of a hotel room door didn't count because the contract was already made down at the front desk. The timing was all wrong. It came too late. Then, in Chapelton v. Barry Urban, D.C., some terms printed on the back of a ticket for a deck chair were completely ignored by the court. And why? Well, who expects a ticket for a deck chair to be a contract? You'd think it was just a receipt, right? The type of document really matters. So, these first 3 cases built the foundation. Rule 1, was there sufficient notice? Rule 2, was it on something that actually looks like a contract? And Rule 3, was that notice given in time? 3 pretty simple rules, right? But what happens when the stakes get much, much higher? So what happens when it's not just about a lost bag, but about something catastrophic? Can a company really use a sneaky clause in the fine print to get out of responsibility for a complete and total failure to do the one job they promised to do? And this is where the courts found themselves in the middle of this massive philosophical tug of war. On one side, you have the principle of freedom of contract, this idea that people, and especially businesses, should be free to agree to whatever they want. And on the other side, well, you have our basic sense of fairness. This quote from Lord Diplock really sums up the traditional view. For a long, long time, the courts basically said, hey, not our problem. Their philosophy was a deal's a deal. If you were smart enough or foolish enough to agree to it, you were stuck with it, no matter how tough it seemed. And this whole idea was pushed to its absolute limit in the 1980 case, Photo Production versus SecureCorp. Get this, a security guard hired to protect a factory accidentally burns the whole place down. I mean, that is what you'd call a fundamental breach, a complete failure. But SecureCorp's contract had this clause that excluded all liability. And incredibly, the court sided with SecureCorp. Why? Because it was a deal between 2 businesses. The court said, look, these are sophisticated parties, they knew their risks, and they should have just gotten their own insurance. The SecureCorp case was really the high point for that strict freedom of contract view. But as the world got more complex, especially with things like software contracts, the court started to realize that maybe a more subtle approach was needed. And that brings us to our final stop, the year 2001, and the case of Watford Electronics v. Sanderson. Here, a company bought a software system that was completely faulty, but you guessed it, the supplier's contract tried to limit all their liability. This time, though, the court didn't just look at whether the words were clear. They pulled out a brand new tool, a sophisticated reasonableness test designed to figure out if it was actually fair to enforce that clause in the real world. And this table here, it really shows you how deep this new test goes. The judges basically become detectives. They start asking all these questions. Were these 2 companies on equal footing, or was one much more powerful?
Was the contract just a standard take it or leave it deal? Did the buyer get a cheaper price in exchange for accepting this risky clause? See, it's not just about the words on the page anymore. It's about the reality of the bargain itself.
So if you take one thing away, it should be this. The law has traveled on this incredible journey from a few simple, rigid rules about notice all the way to this modern, flexible balancing act. It's a constant weighing of scales between the freedom to make your own deal and the need to make sure that deal is actually fair and reasonable. And this timeline just lays that whole journey out perfectly. We started with the basic reasonable notice test. Then, in the 40s, we added the rules about timing and the type of document. 1980 saw that peak of pro-business freedom with Securicor. And finally, in 2001, we arrived at today's much more nuanced reasonableness test. It's a legal story that has literally evolved right alongside our modern economy. Which leaves us with a final and frankly massive question for our own time. In this world of endless digital terms and conditions that we scroll past to one click, I agree, what does reasonable notice even mean anymore? The principles from these 100-year-old cases are still the bedrock of the law, but how they're going to apply in our digital world? Well, that's a story that is still being written.